of immovable property are dealt with in this section. So whenever we are invoking the provision of section 54, we shall be taking into account that these all provisions relate to immovable property. So there should be a subject matter, and that subject matter is immovable property. Now when we are invoking the provision section 54, this subject matter should be situated within the municipal limit. And if it is not situated within the municipal limits, then the section 54 is immaterial. So number 2, in the subject matter, it should be situated within the municipal limits to constitute the subject matter of sale. Number 3 is the transfer or conveyance. As you know it very well, that the transfer changes the hands of the owners. Once a property is in the hands of one person as an owner, he hands over the property to another person by changing his hands. It is a transfer by one person to other. So the transfer or conveyance is one of the essential elements of sale. If the property is not transferred by a transaction, if the property is not transferred by an agreement, if the property is not transferred on the basis of a transaction entered into between the parties, it shall not be a sale. The sale shall only be when there is transfer of ownership, or the ownership is conveyed to the other person. And the 4th one is the price or consideration. Section 54 does not speak of consideration, but it simply says that sale is a transfer of ownership for a price. So when there is a question of price, the superior courts also added the word consideration, meaning thereby that there may be some other considerations for the sale instead of price. But so far as section 54 is concerned, it does not speak of the consideration. It only speaks of the price. So the sale is a transfer of ownership in exchange for a price paid, or promised, or part paid and part promised. So the 4th one is in its effect the price. But the superior court said price or consideration. So in fact, if we go into the depth of the findings of the superior court, those are meant the price as a consideration. So the price as a consideration should be part of the contract, because there can be no contract without consideration. So when we are speaking of the price, we are speaking of the consideration. Where there is a sale, there is a price. And if there is no prefixation of price, there can be no sale. So the sale, when we define it in the stricto sensu, as laid down in section 54, we mean to say that there should be a price. And the price is in the terms of money. The price should be money, whether promised to be paid, or partly paid, or partly promised to be paid. This part of the section is of greater significance. For a price paid, meaning thereby that the whole of the price has been paid. But the lawmaker does not stop the definition here. He further extends it. Are promised, meaning thereby that the price, if promised to be paid, it may constitute a good sale. Are promised, are part paid and part promised. Some of the amount is paid and some of the amount is not paid. Then in this situation, it will not affect the sale. So if we go through this section, we find that fixation of price is a sine qua non. Payment of price is not a sine qua non. Payment of price is not essential for the validity of a sale that may be promised to be paid. So the price, how it shall be paid, has three kinds of payment. Number one, total amount paid. Number two, total promised to be paid. And then half paid or some portion paid, some remains to be paid afterwards. So for the purpose of determining sale under section 54, the definition requires 4 ingredients, and these 4 ingredients relate to the transfer of ownership and for the price. So the basics are the transfer of ownership and the price, and the elements revolve around it, that there was a price fixed and there was transfer of ownership. If the price is fixed, ownership is not transferred, it is not sale. If the ownership is transferred, but the price is not fixed, then it is not a sale, it may be something else. A person has unfettered powers to dispose of his property in any way he likes. He chooses to make a gift in favor of any other person without payment of any price, without any exchange. Even then the transfer of ownership takes place. But in this situation, when there is no element of price, it shall not be a sale. The sale only takes place when there is a fixation of price and there is transfer of ownership. But now the question is, how the ownership is transferred? Mere declaration that I have transferred the ownership, is it sufficient? Mere saying that I have received the price of the property, is it sufficient to constitute a sale? The answer is no. The law requires something else for the purpose of completion of sale, and that is, such transfer is effected through a registered instrument. I am going through that part. Sale how made? Such transfer in the case of tangible immovable property of the value of 100 rupees and upwards, or in the case of a reversion or other intangible thing, can be made only by a registered instrument. If the price fixed or promised to be paid or partly promised to be paid is 100 rupees or less than 100 rupees, then there is no need of registration of the document. But if it is more than 100 or upward, if it is 100 rupees or upwards, then it must be through a registered instrument. Meaning thereby that the sale cannot be completed without registration of the document. If anybody says that I have executed a sale deed and I have transferred the ownership to the other person, I have received the price, is it the sale complete? The answer is no, sale is not complete. Because section 54 requires that the sale is made through a registered instrument. In other words, we can say that title of the vendor passes on to the vendee on the registration of instrument. Now here is another important point which I am going to explain. Suppose a document